Hello and welcome. This Supreme Court term ended with an array of blockbuster decisions that will affect the lives of millions of people, touching everything from access to healthcare, to public education, to the tools that courts can use to stop illegal government actions. In addition, some of the court's most consequential rulings weren't in its headline decisions, but rather in its so-called shadow docket, often issued without any explanation at all. These rulings came against the backdrop of an executive branch that's been testing the limits of its authority and at times the boundaries of the Constitution itself. Today, we're going to unpack the court's most significant decisions and what they mean for the rule of law at a time when democracy is under strain. I will be your moderator for the day. I'm Alicia Bannon, director of the Brennan Center's Judiciary Program and its Kohlberg Center on the U.S. Supreme Court. As you may know, the Brennan Center is a nonpartisan law and policy institute that works to strengthen and defend our systems of democracy and justice so they work for all Americans. While we cannot support or oppose any candidate for office, we can, and today we will, vigorously debate the policies and positions that matter for our democracy. Civility is important to all of us. Those who post rude or inappropriate language in our message streams here on YouTube and Facebook will be removed from the conversation. You can follow along with the conversation on social media with the hashtag Brennan Center Live. Now to today's program. We have an all-star panel here to offer their expert insights into the Supreme Court. We're thrilled to have Joyce Vance, who's the former U.S. Attorney for the Northern District of Alabama. She's currently a distinguished professor of the practice of law at the University of Alabama School of Law, as well as a senior fellow at the Brennan Center. Next up, we have Cecilia Wong, who's the National Legal Director of the ACLU. And then finally, we have Kim Whaley, who is a professor of law at the University of Baltimore School of Law. Good afternoon, and thank you all so much for joining us. Now we're going to get to some questions. And for members of the audience, we will save time at the end for you to also ask your questions. So please, you can put them in the chat and we'll try to get through as many as we can. So we're going to start, I think, with one of the term's most closely watched decisions, which is Trump v. CASA. Many people heard about this case as the Birthright Citizenship case, but the court didn't actually rule on that issue directly. Instead, the case focused on nationwide injunctions. So Cecilia, I'm going to kick things off with you. Can you please, in layperson terms, walk us through what are nationwide injunctions, why were they central to this case, and what did the court decide?
Sure. Thanks, Alicia, for having me. So nationwide injunctions, or to use the court's term, universal injunctions, are orders where a district court holds that the defendant's actions are unlawful and then issues an order, a remedy, that extends beyond the plaintiffs in the case without making findings about why that relief is necessary for the plaintiff in that case. A typical example would be where a district court says that an executive policy is unlawful and then says that the policy shouldn't go into effect at all, where the case really is teed up to involve just the plaintiff's claim that the policy shouldn't apply to them. So that in general terms is what a nationwide or a universal injunction is. I should say that the issue of whether nationwide or universal injunctions are proper under federal law is a procedural issue that doesn't align neatly with ideology. Universal injunctions have been criticized both on the right and the left as plaintiffs on both sides of important issues about executive branch power and about civil rights have gone to the federal courts in various kinds of cases over many years. And the problems have been especially heightened in cases where there's an issue with a universal injunction combined with the plaintiffs forum shopping, where they're going to bring their case in a district court where they have a very high chance of getting a judge who is perceived as being partial to one side or the other of the case.
Thank you. So can you say a bit then about what is this case going to mean in terms of both the power or the role of lower federal courts when it comes to checking national policies? How might it affect other kinds of cases that are going to be that are being brought against the Trump administration or other actors?
Sure. So Trump versus CASA is a really curious vehicle or curious case for the Supreme Court to take up the question of universal injunctions. And I'll explain why I say that. Of course, the CASA case is a combination of three different cases arising in three different federal appellate courts that, as you said, Alicia, challenged President Trump's birthright citizenship executive order. The case in the Supreme Court was on the emergency docket, or the sometimes called the shadow docket, and the Trump administration wasn't challenging in this particular application the merits of, wasn't bringing up the merits of the birthright citizenship issue. Instead, what the Trump administration said was very narrow. It said to the Supreme Court, you should limit the court orders that were that came out of these cases to granting relief only to these plaintiffs in these three combined cases. And the reason I say is a curious case for the Supreme Court to reach out and opine broadly about universal injunctions in is that there were 22 states, various individual expecting parents and nonprofit organizations who challenged the birthright citizenship order. And I think on the record in front of the Supreme Court really made the case for why any lower court order that blocks the president's birthright citizenship or executive order from going into effect has to be nationwide. After all, you don't want a patchwork where there's one rule about citizenship in 22 states and a different rule in 28 states, especially given that people move from state to state. What happens when people move? So it was a really strange case, and I think the court really kind of reached out, bent over backwards to reach this issue of universal injunctions. Now, what's the broader impact is the question. And I would submit that Trump versus CASA is actually going to have a modest impact, both on the birthright citizenship cases and more broadly on cases challenging federal executive action. The court itself, in the majority opinion, said they're not going to touch the issue of President Trump's executive order and are going to keep the freeze on the executive order for at least 30 days. And they sent these cases back to the lower courts. And I think theoretically, these lower courts could simply enter the same nationwide injunctions and simply give more reasoning to explain why that is needed for these 22 states and other plaintiffs in the case. I should add, there are many other cases challenging the birthright citizenship order. And the ACLU is among many other groups who immediately went into court and filed a proposed nationwide class action, which the Supreme Court's ruling, CASA doesn't touch. And finally, I'll say, Alicia, that as to the broader effect, I think that even before the court decided this emergency application in Trump versus CASA, both lower federal courts, district courts around the country, and litigants who are frequent challengers to federal executive action were already aware that the Supreme Court was disfavors universal or nationwide injunctions, and we've all been litigating accordingly, being careful not to rely on a nationwide injunction, or where we are seeking a nationwide injunction, we've been careful to explain why that's needed for the plaintiffs in the case to have complete relief. So at the end of the day, I think Trump versus CASA, notwithstanding the president's crowing about the big victory he won, is going to have a modest effect, both in the birthright citizenship cases and more broadly.
Thank you. Kim, I'm going to pull you into the conversation now. Could you say a bit more about where things stand with respect to birthright citizenship? And I guess because that's I think what drew people to this case in the first instance. Will the government be able to deny citizenship to some children born in the United States? How do you see the broader implications of this case?
Yeah, so thank you again, or thank you also for having me. It's really quite an honor to be here. I've been a little less sanguine, I guess, about the implications of this case than Cecilia, who has a lot more litigation experience, and so I would listen to her over me. But what we're talking about here for non-lawyers is something that's expressed in the United States Constitution under the 14th Amendment that guarantees birthright citizenship. And when you're talking about conservatives on the U.S. Supreme Court, they tend to purport or claim to be textualists. We're conservative. We stick to the language of the Constitution itself. And then, the Supreme Court in the 1800s rejected the very argument that the Trump administration is making to get around birthright citizenship, the argument that somehow your parents' citizenship influences your entitlement to birthright citizenship. So this shouldn't be an issue anywhere in the country. It should be well settled because the Constitution actually creates the Supreme Court. It is above the Supreme Court. It binds the Supreme Court. Trump issued these orders, this executive order. These judges across the country said, wait a minute, this is obviously unconstitutional. We're going to freeze it. As that was being appealed to the higher courts, these injunctions, that's when the Supreme Court stepped in and snatched it to address this universal injunction question. And as Cecilia indicated, basically what this means is if you think about, say it's a private actor that builds a smokestack next to you that's belching pollution in your neighborhood. Your neighbor gets a court order, an injunction telling them to shut down the smokestack. Everyone in the neighborhood benefits from that. Essentially, what the Trump administration is saying is when it comes to, and other presidents, Biden as well, with student loan, for example, there are some issues with these universal injunctions. They're saying, listen, everyone who's affected has to get their very own court order. So where things stand right now until July 27th, those injunctions are in place. But after that, in theory, the Trump administration could go and start enforcing the birthright citizenship ban across the country unless these orders are reinstated. So the Supreme Court sent it back to the states to say, listen, you need to think about how to narrow your injunctions. And they made a distinction between universal relief and complete relief. You've got to decide what complete relief means. Since the Judiciary Act of 1789, judges have had the authority to issue equitable relief. That is to help people, complainants when bad things are happening, to get somebody to stop bad behavior. So as Cecilia indicated, these 22 states made the argument that, listen, if we don't get nationwide relief and our judges say the Constitution applies, but our neighboring states say it doesn't apply, you might have folks coming into our state so they get their citizenship recognized. You're talking about people that without birthright citizenship would not have a state anywhere on the globe. They wouldn't have a nation. So there's a lot of questions, I think, as far as moving forward, whether Trump is going to go ahead and enforce what appears to be an unconstitutional executive order, pending a race to the courts to get an injunction that the Supreme Court will uphold, or a class action, which is more complicated, that the Supreme Court will uphold. And then you've got questions of enforcement. For example, who's going to decide when a baby's born in the hospital where their citizenship comes from? I've had children, you get a Social Security card in the mail. Is it going to be the doctors? Is it going to be the nurses? Do they have to have some government agent come in? How far in terms of your personal genealogy will birthright citizenship go? Will you have to have grandparents that had citizenship that was not by birthright? All these things the Trump administration needs to iron out if it's allowed to circumvent the U.S. Constitution in this way. Now, the court said class actions are a possibility. As I said, that we've already seen at least one court use Rule 23 to get around this ruling. I think there were 19 universal injunctions so far imposed against Trump policies, that those all have to be revisited. The court also said maybe you could use what's called the Administrative Procedure Act, which is always essentially effectively is a way to get universal injunctions. That's under a separate law. So if it's basically anytime you kind of want to challenge government policy that comes through the executive branch, you use this statute called the APA. And so if the Trump administration comes up with a written policy guidance to explain how they're going to implement their birthright citizenship executive order, that policy guidance then could maybe be challenged under the APA. That's very complicated, and there are ways of getting around the APA. So for me, just in terms of drafting that order, so for me, I'm really looking to see what the Trump administration decides to do after the Supreme Court's basically its ruling banning universal injunctions and requiring narrow injunctions goes to an effect on July 7th. What is it, 27th? What is it going to do to, if anything, to try to enforce its executive order, or is it just going to wait and see what the lower courts do? I think given the Trump administration's very aggressive tactics in terms of enforcing Project 2025 and other aspects of its policy, I think it's unlikely that it's going to sit and wait to see how these revised injunctions percolate in the lower courts and make it up to the Supreme Court. But we'll just have to see, Alicia, how that plays out.
No, thank you for that. So I think it definitely sounds like there's a lot we don't know yet about the practical impact of what this ruling is going to be, and maybe some differences in terms of predictions of exactly how significant. I think one thing that seemed very clear from both of you is one aspect that was very striking about this case was, again, that why this case, the court kind of reached to bring in and address something that it didn't really need to do. And now we're kind of living with the repercussions of that. Joyce, I'm going to turn to you now and pull us in to talk about another big case that came out this term, Medina v. Planned Parenthood. Can you give us an overview of this case and how the court reasoned its way to allowing states to exclude providers like Planned Parenthood from Medicaid?
In terms of court, you know what the blockbuster case is. We all remember the year that the Supreme Court rolled back Roe versus Wade. Dobbs was the case in that term of court. I view Medina versus Planned Parenthood as one of the sort of quiet blockbusters this term. It didn't initially get a lot of notice. I think it'll have a lot of play for all of us, frankly, in years to come. It's authored by Justice Gorsuch. It's a 6-3 majority with the 3 Democratic appointees in dissent. And the technical holding has to do with Medicaid's any qualified provider provision. You have a right to pick any qualified provider to give you care, and if you do, Medicaid has to cover that. The holding, however, says that any qualified provider provision is not clear, it's not unambiguous, so it doesn't confer a private right on Medicaid beneficiaries to choose their own provider. And here's what that means. It means that healthcare providers like Planned Parenthood, a party to this case, can't bring suits to enforce that any qualified provider provision in the Medicaid statute. So look here, I mean, this is not like South Carolina is doing abortions, right, at every wayside doctor's office. They're in essence barred from providing them. They are providing primary care for patients, and many patients choose them, especially people who are low income or in underserved areas where they may be the only choice, the best choice. These patients are being told you can no longer have the provider of your own choice. Even though the law guarantees you that right, we, the Supreme Court, are going to strip away your ability to sue to enforce it. So if that sounds absolutely crazy to you, you're right. I mean, this is a part of the Supreme Court's special jurisprudence when it comes to abortion. They sort of twist themselves into law and precedent-defying pretzel logic in order to restrict women's access to abortion, or even in a case like this, not to abortion, just punishment for an abortion provider. It's a ruling that elevates culture wars to the status of law and frankly punishes Planned Parenthood for its place in history. So it's something that should disturb us at that sort of theoretical level, but also the prudential level, that states are now free to exclude providers from Medicaid programs based solely on their association with abortion services. And even if those services are separately provided and the provider is otherwise fully qualified, a provider that they should be free to choose, they no longer have the ability to do it. This case at bottom is Republican justices trampling on patients' rights and on established federal Medicaid law in order to get revenge on Planned Parenthood.
Joyce, thank you for that. And I love this idea of a sleeper blockbuster, the ones that we weren't necessarily expecting coming. In dissent, Justice Jackson raised broader concerns about this ruling in terms of kind of broader civil rights protections. Can you speak to that? What kinds of consequences might this ruling have beyond healthcare access, beyond abortion and Planned Parenthood?
She didn't. And I'll just say, I often like, no matter what the case is about or its outcome, I often like to read the dissent. I sometimes think if you read the dissent first, it gives you an interesting lens for reading the majority opinion. I did that with this case. Justice Jackson writes the defense. She's joined by Justice Kagan and Sotomayor. And her criticism of the majority opinion is very interesting and it's very specific. She contests their conclusion that because the single word right does not appear in the free choice of provider provision in the statute, the section doesn't confer individual rights. And she says, come on, guys, you don't have to use just one word in order to confer a right. She focuses on the way that the decision denies patients the freedom to pick their doctor, despite the law's very clear conveyance of that right. And so it is in many ways a civil rights opinion. She writes, and I actually want to read to you from what she wrote. She writes, she writes, the court's decision to foreclose Medicaid recipients from using Section 1983 to enforce that provision thwarts Congress's will twice over. Once in dulling the tool Congress created for enforcing all federal rights, and again in vitiating one of those rights altogether. So she's focusing on Section 1983, which is a kind of lawsuit that lets individuals sue state and local government officials for violating their constitutional rights or other rights that are guaranteed by federal law. It's a very primary mechanism for letting individuals seek redress when their civil rights are infringed upon by state actors. And Justice Jackson is saying this is a foundational right that goes back to when these sorts of statutes were being written following the Civil War in many cases to guarantee civil rights. And the Supreme Court has just lackadaisically pulled the rug out from under people. I think if you take one thing away from this case, it's the observation that she makes in her dissent that the case gave the Republican-appointed majority the opportunity to cut back on two things that they really dislike. One is access to reproductive care. The other is access to the courts to vindicate individual rights. And the court in this decision manages to cut back on both of those things when it was unnecessary. This should have been a simple case following long-established precedent that said people have the right to choose.
Thank you for that. I'm going to move us on to talk about a few additional cases with significant implications for LGBTQ plus rights. One of them was United States v. Skrmetti, one of the big blockbusters of this term that upheld Tennessee's ban on gender-affirming care for minors. And Cecilia, I'm going to pull you in to talk about this. The ACLU litigated this case. Can you talk to us about what the court decided in Skrmetti, how it fits in now to the broader legal landscape around LGBTQ rights, particularly for trans people?
Of course. So the ACLU sued the state of Tennessee to challenge Tennessee's SB1 law, which bans certain medication treatments that, and I'll quote from the statute, enable a minor to identify with or live as a purported identity inconsistent with the minor's sex, or to treat gender dysphoria. So in effect, Tennessee's SB1 law prohibits the use of hormone treatments and puberty blocker medications for transgender adolescents, but permits the same treatments when used to affirm an adolescent's sex assigned at birth. In short, SB1 took away essential health care for our three clients who are trans teens in Tennessee and their parents. These families had consulted over a long period of time with their physicians and determined that this was necessary medical care, and their state government took that care away from them. In the U.S. versus Skrmetti case, the court upheld SB1 and applied a lower level of constitutional scrutiny. Basically was more deferential to the state of Tennessee in scrutinizing whether SB1 is unconstitutional and violates the Equal Protection Clause. Normally in sex discrimination cases, which we said is a standard that should apply here. The court applies what's called heightened scrutiny and looks at the state's rationale for having the law and in order to make sure that there isn't invidious sex discrimination. The majority of the court here declined to apply that heightened scrutiny and instead held that SB1 is not a sex-based classification, even though the statute by its terms it refers to sex. And instead, the Chief Justice, writing for the majority in Skrmetti, held that the law classifies based on age and medical use. So the outcome here in this loud blockbuster case this term is devastating for our three clients, these three Tennessee families with trans teens and other trans teens and their families. But I do want to say that this is a mitigated disaster, not an unmitigated disaster, because there's a silver lining in that the court did not reach out and say that discrimination against transgender Americans has a different constitutional standard than other forms of sex discrimination. The court didn't reach that question, which would have been a risk in the case. And instead, the court saved that, left it open for another day, which means that all of our other cases defending the basic equal rights of transgender Americans will proceed, including in two cases that the court's already accepted for the merits calendar for next year, where we are challenging bans on trans girls and women participating in sports.
Thank you for that. And it was kind of a wild path that the court took to get to this point where they didn't actually rule on that question, and they pulled out a kind of notorious case where the court had held that pregnancy discrimination did not constitute sex discrimination. And sort of when I was in law school, I viewed that as, this sort of cuckoo kind of almost discredited view, but is still law, and now is been kind of brought to the fore in the context of their analysis of Tennessee's ban.
That's right. The case you're talking about is Geduldig, which basically said that laws that apply to people who are pregnant aren't sex discrimination because it's just incidental that people who are pregnant are women. And the court applied that logic in this case as well. The kind of pretzel logic that Joyce was talking about in this case, as the dissent points out.
And Kim, I'd love for you to come in to talk about another major LGBTQ rights case this term, Mahmoud v. Taylor, which related to the rights of parents to opt their children out of public school instruction related to LGBTQ identities. Can you say a bit about this case and particularly what it suggests about how the court is thinking about religious freedom and parental rights in education and how it might affect inclusive curricula going forward?
Yeah, so I think one overarching point that's coming out of this discussion that I think law students don't always understand coming into law school is how ambiguous law is. That there's almost always two ways of construing ambiguous language, whether it's in a statute or it's in the Constitution. And so when the justices on either side make these decisions, there is an element of subjectivity, always. Judges judge. That's the idea. There's a judgment. This case involves the First Amendment right to the free exercise of religion. And Justice Sotomayor, in her dissent, to pick up on Joyce's point about the nuggets that are in dissents, basically accuses the majority of creating a new right under the free exercise clause. This involves Montgomery County schools here in Maryland. My children went through Montgomery County schools, or still are, having a policy that allowed parents to opt out of certain educational environments if they object to the content. And they changed that policy. And in this instance, the Montgomery County was starting to introduce LGBTQ plus inclusive storybooks into its English language arts curriculum for elementary school students. So this included books with titles like Born Ready, about a transgender elementary age child, or a book called Prince and Knight, about a prince who falls in love with a male knight. And parents got upset, and they sued under the free exercise clause of the Constitution, basically arguing that this indoctrinated their children into an ideology that's inconsistent with their religious beliefs. There has been a case called Wisconsin versus Yoder, where the Supreme Court has recognized the right of parents to have agency when it comes to the religious education of their children, including with respect to public schools. So, for example, if your child doesn't want to say the Pledge of Allegiance as a mandatory element of their morning ritual, they don't have to. In this instance, Justice Alito, in his majority decision, sided with the parents and articulated the test as whether a policy substantially interferes with the child's religious development. And he said, these books are unmistakably normative. That is, they're really trying to teach a certain ideology that might be inconsistent with certain religious beliefs. Now, the dissent said, no, there's no constitutional right to not be exposed to things that you don't like. That exposure to LGBTQ plus ideas is not compulsion in the way that forcing to take the Pledge of Allegiance might be. And the dissent underscores the pragmatic nightmare here that the Montgomery County School District also underscored. The idea that, listen, if we allow all these opt-outs, as I said, they changed the policy to narrow that possibility, we have to have additional staff that is available to keep track of these kids while we're teaching these other these themed books. And in addition, what's the slippery slope? Where does it end? Does it, if you object to women working, for example, based on your religion, would a book with a woman astronaut, would that be available for an opt-out? What about evolution? What about if you have a storybook about wizards and witches, and that's inconsistent with your religious ideology? Or what if you have your kindergartners do a picture about your family, and one child's family involves two moms, and they draw a picture of their two moms? Would that be a problem that the teacher would then have to make an announcement and allow the parents to opt out of that? Or if they've got a picture of a male teacher has a picture of their husband on the desk? So the argument is that this creates this really broad slippery slope when it comes to this idea of religious expression and religious freedom that is going to be expensive and difficult for schools to administer, and will, for practical matters, might just make it so that teachers are careful not then to have LGBTQ plus themed issues in the classroom just because it's so difficult to administer. And then that's going to alienate children that want to celebrate that aspect of their identities or their family's identities. And in connection with your question as for the broader kind of trajectory of this, and I'm interested in my colleagues on the panel thought of this, my sense is that we're seeing the free exercise of speech and religious freedom being used in a way to override other rights. That is, override bans on discrimination. We saw this with a case involving a web designer who didn't want to make websites for gay couples, for example. We're seeing the court kind of imbalance or so say, like, way more heavily religious freedom, and other rights are not being taken as seriously if there is a claim of religious discrimination floating around in there. And I should just say there's 370 different religions in Montgomery County School itself, district itself, and 47 million public school students across the country. So how far parents decide to go with this new right is something we're just going to have to keep an eye on, and whether in a future case the Supreme Court decides to pull back on this interference with religious development test that Justice Alito unveiled in this ruling.
Thank you so much. I'm going to turn it now to Joyce to talk. One of the big themes of this term was not actually a particular case, but rather the rise in significance of what's known as the Supreme Court shadow docket. It's a very ominous sounding name. So Joyce, for folks who aren't familiar, could you just first explain to us what is the shadow docket? I know we've already mentioned it a few times throughout the conversation thus far. How has the court used this term, particularly in cases related to challenges to the administration's policies? Oh, you're on mute, Joyce.
For some reason, I can't remember that today. I apologize. The shadow docket is a term that's used. It's actually been popularized by our good friend Steve Vladeck, who's a law professor at Georgetown, who wrote a remarkable book on this topic. But it's really nothing sinister. It's the court's emergency docket for handling cases or motions or matters that require an immediate decision. Every court has something like this. The Supreme Court often uses it, for instance, to decide last-minute appeals on death penalty cases. So it's not like they've created something malevolent. The problem is that increasingly in recent years, the court has shown a willingness to take cases that are in a very preliminary posture, like a case where a judge grants an injunction. That's not something that happens after full development of the facts and law in the case. It's just an early effort to press the pause button so the litigation can get underway. Those injunctions get appealed up to the Supreme Court. And then on the shadow docket, which, for real is happening here in darkness, the court decides significant issues without full briefing, without oral argument. This isn't the court's traditional docket. And we get justices issuing decisions almost always without signed opinions, without sometimes any opinion at all. We might get a dissent from a justice or more who vehemently object. Last week, we got a concurrence from Justice Kagan explaining the reason that she had joined her brethren on the other side of the political divide to concur. But for the most part, we get a decision without a rationale. And that's a terrible way to develop the law. And all too often, the court expects the lower courts, especially the district courts, to discern with no guidance what they meant and what they want the lower courts to do. And we saw a great example of this last week in this case where the United States wants to take people who are deportable but can't be returned to their country of origin, and it wants to send them off to what we've taken to calling a third-party country. They want to render them, for instance, to South Sudan. And so we had a case like that this week where the district court had issued an injunction that prevented that from happening. It made its way up to the Supreme Court on the shadow docket. The court says, no, you can't do that. And the government goes on its merry way. But the district judge says, listen, I've got another injunction in place that the Supreme Court didn't touch that says that these original folks, these plaintiffs, can't be turned over to South Sudan. And so he tells the government, you can't do that. And the Justice Department goes straight back up to the Supreme Court. I'll skip over the murky procedure there. But the court seems to take umbrage with the district judge for not guessing what they meant. And they, again, reverse him and say, no, United States, you can send all of these folks to war-torn, dangerous South Sudan, where these men will be tortured, if not worse, without even the most minimal of due process. So look, I clearly don't like the outcome of that decision, but when we object to the shadow docket, it's really more on policy and on procedure grounds, because this has a serious impact on the rule of law and democracy, and the expanded use of the shadow docket to make what in essence are substantive decisions without full briefing and without full opinions ends up undermining the rule of law and transparency, which are essential to democracy. And so in this moment where the Supreme Court, where the public's confidence in the court, the public's opinion in the court is the lowest it's ever been since Gallup started polling on that, instead of working to enhance public confidence in its integrity, the Supreme Court undermines it by taking these shortcut steps to issue substantive rulings.
Thank you for that. And we have a bunch of great questions from the audience. We're going to turn to them in just a minute. But before we do, I wanted to turn to Kim to hear about just one more case that was on the shadow docket. We've heard about several already. But one more before we turn to the audience, Trump v. Wilcox, which involved the president's removal of independent agency heads. Could you briefly explain what the court did and why it was significant?
This is a great example of what Joyce was explaining. So the court basically reversed a law, or a case that's been on the books for 90 years. Under Article 2 of the Constitution, the president has the power to appoint executive branch officials and judges. So anybody that in a cabinet level, the president appoints them, the Senate confirms them. But it says nothing about removing people or firing people. Many years ago, the Supreme Court said, well, removal has to be part and parcel of appointment, because if you can't remove bad employees, you can't manage your team. However, the court said in a case called Humphrey's Executor in the 1930s, Congress, when Congress creates agencies and identifies, the whole executive branch, with the exception of the Treasury Department, is all created by Congress, by statute. That's why DOGE has been such a controversial thing. So when Congress creates agencies and gives the president people to appoint, it can insulate certain positions from removal by requiring the president to have a good reason, what's known as cause. Two of those people or positions included the head of the National Labor Relations Board that deals with like union and employee, federal employee issues, as well as the Merit Systems Protection Board, which is also a federal employee type, mechanism. If you've got issues with respect to employment in the federal government, they can't be removed except for cause, except for a reason. Donald Trump fired the two women that were in those positions. We have this case, Humphrey's Executors, that says that the Congress can restrain the way they're removed. There's no question they were not removed for cause. And the court basically sided with Donald Trump in a very short decision, which, like as Joyce was saying, that doesn't explain, wait, what happened to Humphrey's Executor? This is a very, very hotly contested and theoretically rich issue that law professors have written many, many articles about. And so, what's unusual, and I know one of the questions people raised in the chat is, wait, is this usual? Haven't justices done this before? We've had conservative leaning courts. We've had, liberal leaning courts. What is unusual with this uptick in the shadow docket is normally the idea is you get things really briefed well with hundreds and hundreds of pages of briefing. You have amicus briefs with different ideas coming in. You have oral argument. You have long decisions, concurring opinions, and dissents. So people know it's a thoughtful, well-reasoned decision that's not about politics and ideology, and gives not only the lower courts, but here Congress, an idea of what it's allowed to do. This basically upended two statutes that have been on the books for a long time without really telling Congress what it did wrong many, many years ago. And that's why in kind of the scholarly legal profession, what the court's doing is really radical. It's not just conservative. Some of these things are on the radical end of things, and very disturbing, frankly, as a matter of just coherent, intellectually honest judicial reasoning.
Thank you so much for that. And I'm going to turn now to some excellent questions we've received from the audience. So I'll pose them and welcome our panelists to jump in with thoughts. The first question I'll pose is there anything, or what can state courts do to step in the face of some of the Supreme Court rulings that we've seen this term? Anybody? Cecilia, would you like to take that up first?
Sure.
I saw you smiling.
Yeah. So there's a lot that state courts can do, and as reflecting that, the ACLU has a state Supreme Court initiative now that started a couple of years ago, and I think there are state constitutions that are so rich in civil rights and civil liberties that are completely parallel to what protections we have under the U.S. Constitution. And of course, it's the state Supreme Courts that have the final word on what their state constitutions mean. And so, to give just one example of the work that we've been doing in state courts on both the issue of trans rights and abortion rights, following or maybe anticipating bad decisions on equal protection arguments in the Supreme Court of the United States, we've gone into state courts after identifying state constitutional rights that would be supportive of the right to abortion care, supportive of the right to equality for trans and LGBT Americans generally. So, for example, after Dobbs was decided by the U.S. Supreme Court, we identified a number of states where we combined state court litigation with ballot initiative advocacy in order to establish the right to abortion care under state law. And then we used litigation to go into those state courts in order to strike down any old state statutes that were contrary to that new right that was enacted by the people of those states. That has been a strategy that we've carried out successfully in a number of states. You've also seen state courts like the Montana Supreme Court repeatedly finding a state constitutional right against discrimination against trans people in the state of Montana. And so there is so much that we can do and that civil rights lawyers and people who are affected by these harmful state laws and federal laws can do in order to vindicate their rights in those courts.
Thank you for that. Would anyone else like to jump in, or I can turn to the next question? All right. How can the court enforce its orders if the Trump administration refuses to comply? Can appointees be held in contempt of court? What are the tools that the court has?
Well, I'll just jump in and say this. The court doesn't have armies that go out and enforce its orders. And much of its authority is set up in the Constitution. It's foundational, this notion of separation of powers and a balance of powers. And then we have an early decision, Marbury versus Madison, literally the first Supreme Court case everyone touches when they enter law school, where the Chief Justice says it is the court's job to say what the law means. And with that comes the responsibility of the executive branch and of Congress to follow those decrees. And this administration is unique in its willingness to go right up to the line in not complying with those orders, if not to cross over. I mean, I think that the constitutional crisis that many of us have contemplated will happen if we reach the point where instead of saying, well, we thought we were implying or complying or we're doing what we need to do, there's a statement from the executive branch that says we're not going to comply with this order. And that is the sort of breaking point that everyone is struggling so hard to avoid, because when that happens and the gauntlet is thrown down, if we get to that point, then the court will have to try to use its contempt power and perhaps some other forces to try to bring the executive branch to heel. And as we've been discussing, I think Kim mentioned that one of the big narrative lines through the cases this term is the ability, the effort by the executive branch to accumulate more power, to sort of say the lion's share of power belongs to the president under the Constitution. And I think the real ability that the courts have here is not only to use contempt and other similar sanctions. For instance, if the government doesn't comply with discovery orders in a case, that's been a very real prospect. A couple of times, the court can rule against the government and say, if you're not going to comply, then we're going to take those issues as proven against you. That's an extremely powerful sanction in civil litigation. So I don't think that we should consider the courts to be a toothless tiger. They're not. They have a lot of play in the joints on these issues. But ultimately, public condemnation of the executive branch, if it were just to openly flout an order by the court, would be critically important here. It's one of the reasons that we need to all stay engaged. This is an administration that will back down if it perceives that public opinion is going to turn against us. That's why Kilmar Abrego Garcia is back in the United States, because we reached a point where people were becoming outraged by the denial of due process. And, nobody ever really thought that due process would be a battle cry for Americans. But we saw people out all across the country holding up placards protesting that said due process or some variant of that. Americans are awake, they are paying attention, and they will provide sort of the counterbalance that the judiciary needs if push comes to shove to hold the executive branch in line. So I'm concerned about this. I think that we should all be worried, because this is an executive branch that frankly wants more power and that looks for these confrontations, which I think is the most concerning part of it. They don't pull back. They go straight into court looking for the confrontation. It's up to the courts to keep them in line.
It's great, and a real call
Alicia-
to action for the public and for all of us to maintain that commitment to the rule of law. Kim, I'm sorry I cut you off.
I'm sorry. I wanted to just jump in there. I mean, I think to underscore Joyce's point, but then to take it a little bit further when it comes to Supreme Court, where I'm coming from, it is absolutely crucial in this moment for everyone to wake up and to make their voice heard. I really think it's not going to be the courts that are going to save us. And I actually think we've crossed the Rubicon of a constitutional crisis for a couple of reasons. First of all, as I mentioned, the Supreme Court has already rejected Donald Trump's argument for outmaneuvering birthright citizenship. So the executive order not only violates the U.S. Constitution, but it violates a binding Supreme Court precedent. In addition, in the Abrego Garcia case, the court did hold that due process applies to these deportations, and the Trump administration isn't doing that, and the Supreme Court is then following up with saying, "Oh yeah, like with these South Sudan deportees, go ahead and do it, even though there isn't due process." So the way I read these cases is that the Supreme Court is becoming as dangerous as the Trump administration, almost as if their own legitimacy is at stake and they know it. So they're not going to do anything that is going to put them in this position where they become completely obsolete. But but Donald Trump and the Trump administration is ignoring directives from the Supreme Court. That has happened, and I think if people don't want to take my word for it, Justice Jackson's dissenting opinion in the CASA, the Trump versus CASA case, the Birthright Citizenship case, I think is really very important to read, and it's very accessible. She writes, the court's decision, I'm quoting, to permit the executive to violate the Constitution with respect to anyone who is not yet sued, that is for birthright citizenship, is an existential threat to the rule of law. And that they use a, quote, mind-numbingly technical procedural query to get around the Constitution. She says that legalese is a smokescreen. It obscures a far more basic question of enormous legal and practical significance. And here it is. May a federal court in the United States of America order the executive to follow the law? Right now, based on the Supreme Court's ruling, that's a question. And when it comes to Joyce's point, when it comes to Donald Trump or any president, James Madison understood this in Federalist 51. If men were angels, we would not need government. That if there's no meaningful checks and balances, if there's no worry that they're going to get in trouble, that there'll be a ticket issued for speeding through the speed limit doesn't matter. And this Supreme Court is not issuing tickets for speeding. And I'll close with this one. She says, eventually, executive lawlessness will flourish, and from there, it is not difficult to predict how this all ends. Eventually, executive power will become completely uncontainable, and our beloved constitutional republic will be no more. This is a sitting Supreme Court justice putting this in writing, and prompted Justice Barrett to say her startling line of attack is tethered neither to any source, is tethered to no meaningful source. I'm paraphrasing. But I think the fact that a sitting Supreme Court justice is ringing this alarm in this way is something we all really need to take account of. And so if for those who are listening, I really encourage you to educate yourself, pull up that CASA case and read the majority and the dissent for this question of where are we in our republic? Is our separation of power system functioning? And I would say we're past the point where we can sit back and not worry about it anymore. And I would take up Joyce's call to arms. Everyone needs to pay attention and have their voices heard, whether it's going to a protest, whether it's contacting your representatives, whether it's just educating yourself as you're doing today and sharing what you learned here with one person, encouraging that person to tell someone else. That's the only way we're going to get this in line when it comes to both the executive branch and, frankly, this far-right conservative majority on the U.S. Supreme Court that is greenlighting lawlessness on the part of the President of the United States.
Thank you. This has been an incredibly rich discussion, and so many themes and ideas that have emerged over the course of this hour. I'm going to turn to each of you with one final question. In a few sentences, what is one thing that you want our audience to walk away with from the conversation we've had this afternoon? Cecilia, I'll turn to you first.
Sure. So I would say first, focus on the big losses for civil rights and civil liberties and the rule of law, to the exclusion of the cases where the court really did stand strong against executive abuses. In addition to the Wilcox case and the DVD case, the third country deportation case, the court also in two ACLU cases challenging Trump's invocation of the Alien Enemies Act to deport people to this gulag in El Salvador, the court was really steady in rejecting the executive branch's arguments that these issues are non-justiciable, in making sure that there is due process, and preserving people's rights to finally get to the merits of the Alien Enemies Act issues in the Supreme Court, probably next term. So I'd say it's still possible to win in the Supreme Court, including in high-profile cases that pit the executive branch against people asserting their fundamental rights under the Constitution. And then the second thing I would say is I join Kim and Joyce in saying, look, it's so important for all Americans who care about these issues to use whatever tools you have at your disposal to make your views known. Because Supreme Court litigation is a small piece of our overall litigation strategies in the civil rights movements. And this litigation overall is a small piece of the overarching long-term strategies that we need to defend and advance civil rights and civil liberties in this country. And so we all need to engage in that long journey towards making our country what we want it to be.
Thank you. Kim.
We are in a moment where not just the executive branch, but the Supreme Court is a potential threat to the rule of law. And we need to be having these conversations soberly, seriously, and to have the courage to not look away, because what we're fighting for is not just the rule of law and the freedoms that come with us for ourselves, but it's for our children and for our grandchildren and future generations. So I just want to thank everyone for being part of this, and hope people feel empowered to have the kind of agency that for generations, Americans that came before us fought so hard for.
And Joyce.
Well, I would echo what Cecilia and Kim just said. I mean, it's interesting that we're talking about the courts. We now return to politics. Take away the fact that you are not powerless, that as an American citizen, you have an enormous amount of power to steer the future. You know, for the people around you, you're the trusted voice, and you can share with them much of what you've heard today, other information that you read. Perhaps if you look at court cases on your own, don't be afraid to share those ideas with people. Even if they're not in immediate agreement with you, they will listen, and you may be able to plant seeds for the future. Because the way we'll reinstitute guardrails in this country is, for starters, with the midterm elections. Congress has remained in this supine position. If you don't like what the Supreme Court is doing, then work to elect a Congress that will vote, for instance, for ethics rules. You don't have to break the institutions to mend them. The Supreme Court, with ethics rules in place, like every other federal court in the country, could begin on the path to being a renewed institution. So don't obey in advance, as our friend Tim Snyder, the now in Toronto historian, likes to say. And do remember that you have a say-so in the future of the country if you're willing to exercise your voice.
A tremendous thanks to our wonderful panel, as well as to our audience for all of your questions. I wish we had time to answer them all. And the Brennan Center looks forward to seeing you at future events. You can be the first to know about our events if you sign up for the events newsletter at brennancenter.org/events. Again, I'm Alicia Bannon, director of the Brennan Center's Judiciary Program and its Kohlberg Center on the U.S. Supreme Court. Thank you all so much for coming.